Glad to be here. Once again, speaking about elections, condominiums, co-ops, and homeowners associations today. As Jeff mentioned, I'm in the Palm Beach Gardens office of K. Bender Renbaum. I am a board certified condo and HOA lawyer with the Florida Bar. And this is what we do all day, every day, help associations. And thank you for being here. Thank you for learning. This is a great course. I will say that the first third of this course, I want to say 25%, the first quarter, is condo co-op related. So those of you who are here for HOA law, who don't deal with condos, who do not want to confuse yourself with knowing about the condo law, which completely differs from HOA law regarding elections, I will give you permission to zone out. You could kind of zone out for the first little bit of this presentation when we are talking about just condo and co-op law. I don't want you to be confused, but if you deal with both of them, please pay attention because, like I said, there are differences in the law here. We frequently have HOA clients come to us who are attempting to use the condo law election procedure, and that's just not always the case. So don't assume, you HOA folks, that you are going to be using the condo election procedure. Like I'll tell you many times during this presentation, HOA elections are pursuant to your governing documents. We do have statutes that guide us with respect to certain issues, but for the most part, they are per your governing documents. As if you are a condo co-op, you probably know that we have a statutory framework for elections, and most oftentimes they are going to be governed by the statute, and your documents really don't come into play that often for a condominium association in terms of your election procedure. There are other issues regarding elections where your documents are pertinent, and that is what we are about to talk about right now. So let me share screen. That's probably the more difficult part for me for the entire presentation here.
And while you're doing that, I'll just quickly mention, I failed to mention earlier, at the end of the course today, when we end the course or when you all leave later on, and please be sure you stay on for the entirety to receive your CE credit, you'll get a link. You'll click on the link and it'll take you to the post-webinar evaluation. And that's what we use to create the content for your to upload the credits. Just wanted to mention that, and we'll put that into the chat later, and it'll pop up automatically when we're done. Allison, back to you.
Okay, thank you, Jeff. Thank you. Okay, so we are going to get started here because there is a lot of information and we have a short period of time. First, condo and co-op associations, eligibility for the board and number of board members. This issue has come up very frequently as of late because we are in election season. I have a feeling that many of you condo people out there have sent out your first notice of the date of the election and the procedures to qualify for the board. And in doing that, we receive many questions about the number of board members. How many people should be serving? Well, this is something that should be addressed by your bylaws. But if your bylaws do not address it or do not provide for a valid procedure for the association to determine the number of directors, the directors will oftentimes default to 5 members. If you're in a very small condo, your director, or you may default to 3 members. Once again, if this number is not provided in your bylaws. So this is a document specific issue as to each association. Everybody is unique. And I could not guess how many directors there are for the various associations. This is something you have to look at in your documents. It's very specific. What is the term of the director? The term of director. Well, oftentimes it's going to be a 1-year term. That's pretty much the default situation. But a lot of times the documents may have been amended to provide for multi-year terms. The law on terms has sort of flip-flopped over the years, but the statute was recently amended to expressly clarify and provide that you can serve more than 1-year terms if provided in your articles or bylaws. Again, we have a term limit here in the Condominium Act, and as of July 1, 2018, condominium board members cannot serve more than 8 consecutive years. unless approved by 2/3 of the members voting in the election or not enough persons are willing to serve. So this is, just to be very specific here, this is a condo law. This is not a co-op law. This is not a HOA law. And again, it's 8 consecutive years. It's not 8 consecutive terms. If you step off for a year, if you step off for a day, this is no longer triggered. You may have remembered for a certain period of time, there were some questions regarding whether service from before the law was enacted counted towards the 8 years. Well, that is, again, has been clarified in the law, and now the service would have to begin as of 2018. So 8 years as of 2018. We're not there yet, but we will be there and we will deal with this. This is regarding eligibility to serve and not eligibility to be a candidate. So keep that in mind when you are at this phase a couple of years from now. The last bullet point on the page here, this has been coming up pretty frequently. Once again, people have sent out their first notice of meeting, and they say, well, you know, we only had 2 people put in their notice of intent, or the same number of people put in their notice of intent as is vacancies that will be coming up. Well, that's great. I mean, that means you have no election. The people who submitted their notice of intent will be deemed to be elected, and there is no need to hold an election in that case. And we'll be talking about vacancies and other issues that are pertinent to this matter as we go through the course. This is probably not the last time you'll hear me discuss vacancies. We do discuss that later in this seminar, I think towards the end. How many, I can't see my page, hold on a second. Oh, board member eligibility. We have for condo and co-ops that you have to keep in mind, your governing documents do not address board member eligibility. Board member eligibility is per the statute, per the Florida Condominium Act. All owners, the statute does say that all unit owners are eligible for the board. You can provide that you have to be an owner to be on the board, but beyond that, you really cannot create your own eligibility requirements. Other eligibility requirements will not be valid. If you do have a situation where your documents provide that you must be an owner to be on the board, we have a special statute right here in the middle regarding trust ownership. Many units that we deal with here in Florida are owned in a trust for estate or other types of estate planning or other purposes. So we have a law here that said if a unit is owned by a trust, the grantor of the trust, the maker of the trust, or any beneficiary who resides as the unit is eligible. So this is a situation that's special for trust owners. And sometimes you will not know, you don't know who a beneficiary of a trust is. That is not of public record, like, who owns the unit. So in these cases, you may need to inquire with the person who submits a notice of intent to provide a copy of the trust or a partial copy of the trust with some portions that may have been redacted to show that they truly are a beneficiary of the trust and that they reside at the unit. The trustee is also able to be eligible for the board as well. So trust, a little bit more complicated, but not so much. We do have a special statute here, which is actually a good thing. We do have guidance. If you have questions regarding eligibility for trust, corporate owners, that's something you have to talk to your lawyer about if you have specific questions about it. So what other eligibility requirements are there? Because there are other eligibility requirements that are included in the statute. One of the laws that came into effect last year that I don't think anyone really paid attention to so much because it was in July and we don't have that many annual meetings gearing up in July is the change to the assessment issue, that you cannot be delinquent in the payment of an assessment to the association to be a candidate for the board. Special for condominium, new change here. For co-ops and homeowners associations, and what was previously provided for a condo was that you could not be delinquent in any monetary obligation. That was scaled back, so you can no longer keep somebody off the ballot for non-payment of fines or other fees, they lost their key card, or they didn't pay their extra parking space fee, that would not be proper. Again, it's very specific, only condos, co-op law and HOA law. If you're paying attention, HOAs right now, this does not relate to you. You are under the law that was that we knew up until July 1, that had been there for quite a while. What other eligibility requirements do we have? We have that you cannot be convicted of a felony and you do not have your civil rights restored as of the date eligibility is due, the last date to make your notice of intent to be a candidate. You have the second bullet point right here: in a residential condominium association, you cannot, co-owners of a unit cannot serve on the board at the same time unless they own more than one unit or there are not enough eligible candidates to fill the vacancies. Keep in mind, eligibility to get on the ballot to be a candidate versus eligibility to serve. I said that before as to the term limit that will be applicable in a couple of years now. There are two different things. Eligibility to get on the ballot is eligibility to be a candidate. And then if you get on the ballot and you get elected, you may or may not be able to serve regarding this co-owner issue. Just to get to the issue right now, the co-owner issue does not relate to co-ops or homeowners association, specific to condominiums only. A candidate means an eligible person who is eligible as of the last date to submit a notice of intent. So you cannot be delinquent in an assessment as of the last day to submit your notice of intent. Does that mean you step into the manager's office and hand them a check that day? No, because we don't know that the check is good, and I wouldn't. That would be a difficult decision to determine whether you were truly eligible at that time. So if you are looking to be a candidate, to be on your board, and all of this is upcoming for you, make sure that you are current in the payment of all of your assessments very soon before that notice of intent is due, because you don't want to push it too far and have a problem with a delinquency issue. That's something that you should take care of well in advance. I keep talking about the notice of intent and when it's due, and I have failed to mention that that is due 40 days before the date of the annual meeting. The first notice is sent out 60 days before the date of the meeting. You have to nominate yourself for the board no more than 40 days before the date of the meeting, and you can also submit a resume or candidate information sheet 35 days before the date of the election. So our key dates are 60, 40, 35, and we will get to the second notice, which is 14 days before the date of the annual meeting. What is the problem with, including somebody who happens to be, a delinquent, just slightly? They've always paid, maybe they changed banks, they forgot to update their automatic payment, or there was some problem, the mail was slow, as we all know these days. What happens if you include somebody who's ineligible on your ballot? Well, that's a pretty big problem. You cannot be the nice person here. The nice woman, man finishes last by including somebody's name on the ballot who is ineligible, because it will automatically invalidate your election. That is a good way to get your election completely invalidated, and now you have to pretty much start over. If you can't do that because you don't have enough time, a completely new second notice will be due to be sent out, again, 14 days in advance. And last bullet point, I've already said 3 times, if the election has already occurred, then it's going to be deemed void and you have to renotice the election, starting with the second notice. This doesn't mean that you now go take new candidate nominations. No, you just send out a ballot again with the correct names and indicate that the reason why you're doing this. Moving on. The notice and the deadlines, which I just actually mentioned, but let's go over this again because this is important. The first notice of the date of the election and the procedure for qualifying for the board must be sent 60 days before the date of the meeting. It actually does not need to include the date, time, and the the time and place of the meeting. It's just the date of the meeting. If you have authorized voting by electronic means, and we'll discuss that in a little bit more detail later, but if you have authorized or adopted a resolution where you're going to use a voting platform such as HOA Vote Now, you will have to include an option for the owner to opt into using that program with the first notice. The Florida Administrative Code provides for certain reasons why an election would be automatically invalidated, and failing to include the consent to electronic voting and the deadline to opt into it is one of those reasons that invalidates your election. So if you've done that, that's something that you must think about immediately and get that notice out with the first notice. As I've mentioned, you have to provide your notice of intent to be a candidate 40 days before the date of the election. Make sure that you provide that to your association with a means that you can establish delivery. Do you slip it under the manager's door on the 39th day? No, because you don't know whether they actually received it or whether that person came, the manager may be out that day. So send it by, certified mail, FedEx, maybe an email with a read receipt, possibly a fax because you get a fax confirmation, some kind of method that you can establish delivery and the date of the delivery so you can ensure that you can get on the ballot. If you deliver your notice of intent by hand delivery, you step into the manager's office and you hand them your notice, they're required to give you a written receipt in that case, so you can establish that delivery. That's the only time when the association is actually required to give a written receipt. But I do know that many associations provide all of the candidates with an email or some kind of confirmation of the receipt of their notice to give some kind of peace of mind. And I think that's a nice idea. It lets the candidate know that you received it, and maybe the association can remind them of the eligibility requirements to take care of before that notice of intent period ends on the 40th day. 35 days before the date of the election, you candidates out there, you must submit your information sheet, your candidate resume. This is not something that's required, but it is something that could be helpful if you're looking to be elected. You can state what your qualifications are. You can include projects that you've helped complete for the association if you're an incumbent board member. You're kind of your platform here. And the association, the current board, the manager, they're not permitted to redact, modify, alter this information sheet in any way. So a lot of times candidates will submit information sheets with their own opinions, I'll say, about what's going on at the association, and the association has to mail that out. It really cannot alter or redact because it doesn't like what the candidate has said. 14 days before the date of the meeting, no less than 14 days, you have to send a second notice of the meeting with or without an election. So if you don't have enough candidates to cause an election, you'll be simply sending the second notice of annual meeting with a regular agenda, approval of minutes, and just your standard items. If you do have enough candidates to cause an election, you need to send a ballot, and everybody will be listed by their in alphabetical order by their last name. You have to send the 2 envelopes, and you have to include an agenda for the meeting. Don't forget, however, to also post this second notice on the property. Many people get very wrapped up into sending out the mailing, I guess I'll call it, with the envelopes and the ballots, that they forget to post the notice on the property as well. That's very, very important. You are required to execute an affidavit of the second notice of the meeting, so it must be sent in accordance with the rules. Be aware, your governing documents may require longer notice periods, and I see this from time to time with the second notice of the meeting. The Florida Condominium Act used to provide long ago that the second notice had to be sent 30 days in advance. So there are many governing documents out there for condos that still are stuck in time and provide that you must send the second notice 30 days in advance. If you are one of those, and you may not know that you are because maybe you didn't read up on your bylaws, and this is something to take a look at, that you are required to send the second notice for that longer period of time. So you would be required to send it 30 days in advance rather than 14 days in advance. So that's something that you want to be aware of so you can mobilize, you can get your meeting mailing ready, all of your envelopes, your ballots, because that is very time consuming. Website notice. I even always forget about this sometimes. For condos with 150 units or more, you need to actually post your notices on your website as well. So this is another posting requirement for condos only, everyone. Condos only with 150 units or more. I'll tell you right now that there is a trend in the legislature to provide for more disclosure to condominium unit owners, and I'd probably bet that we will see this 150 units or more be reduced to maybe 100, 50, even 25. I've heard people talk about that. You out there, if you're in a condo with 25 or more units, then you would be required to have this website and post certain information on the website in accordance with the statute. So we'll see what happens with that. Nothing is, there is no law right now, but that is where I see the trend headed. So if you are considering implementing a website, it's something to look into now, possibly. Electronic notice. I did talk about electronic meeting platforms. This is different. Electronic notice is something completely separate. If you would like to email notices, which you can do if the unit owner has consented to receive official association notice via email. And for those of you listening, for HOAs, co-ops, this relates to everybody. So I think it is duplicated in the other sections later on, but I'll probably skip over it to save some time. The point of this slide, and it really does save a lot of money. Save money on your mailing, your stamps. Stamps are expensive, and mail is taking very long to get there lately. So if you've had owners consent to receive notice via email, that's great. You don't have to put this in the mail. I will say that an email with the second notice is kind of difficult if you have an election, because we know in a condo world you have to use the double envelopes, and I'm not sure how you email a double envelope and make it a meaningful process where the owner can follow and get that document back to you. So I would not recommend using the email for your second notice if you have an election, but you could do it in addition to the mail. That's what I would recommend. So for quorums, for condominium and co-ops, there is no quorum requirement to hold an election, but at least 20% of the eligible voters must cast a ballot. For HOAs, we'll talk about that later, it's a little bit different, but you do not need a traditional quorum for a condominium or co-op election. Last on this page, very important, no proxies can be used in the election for residential condominium or cooperative. Secret ballots only, secret ballots only. So what are you gonna do? You've sent out your first notice, you got your candidates in, you prepared your second notice with your ballots and your envelopes, you sent everything out to the owners. What happens now? Well, we're gonna have the meeting. And the first step at the meeting is to have anybody who has yet to cast a ballot submit their ballot. Once everybody has submitted their ballots and you think you have it rolling now, you have your impartial election committee check in the ballots. Well, what is check in the ballots? Checking in the ballots basically means you're verifying that the person who signed the ballot is actually an authorized voter and that they are ready to be opened at the proper timing. So you want to see that 20% of these authorized voters have submitted a ballot. Nobody has submitted two ballots. If you submit two ballots, both ballots will be invalid and they will be set to the side and they will be disregarded. They will not be thrown away. They will not be opened. They will simply be set aside and disregarded. Once the election ballot is received by the association, similarly, it cannot be rescinded or changed. So that's that. The impartial committee has to have this check-in process on the same day as the election. You can have it earlier that day if you notice it as a committee meeting, but otherwise it actually has to occur at the beginning of this meeting. The impartial committee will sit there, and sometimes it takes a really long time to verify all of these ballots, and that is why the electronic voting is sometimes very helpful. It makes this process a lot quicker and easier for everybody who is at the meeting. But the impartial committee will check these ballots in. The impartial means no members of the board, no candidates for the board, or none of their spouses can be on this committee. So I like to, it depends how many units we're dealing with, but you want to at least have 3, 4, 5, 6 people. I've even seen, 8 people if you have many, many, many units over there. If you have a situation where, an authorized voter did not vote, then you will disregard the ballot and once again put it to the side. Okay, after all that's done for a condominium and cooperative association, now you're moving on to opening the ballots. Opening the ballots is in the presence of the owners. You don't go into a back room to do this. Everyone is permitted to watch this occur. That is their right. But, they can't be disruptive or look over your shoulder so much that it makes the process impossible, which I've had before, and it's been very difficult for these people to do their work opening the ballots with somebody over your shoulder and somewhat being intimidating. So while you do have the authority as an owner to view this process, you need to be respectful of the impartial committee, because really they're volunteers who are doing this for the association, and it's an important job. The first thing you do is you remove the inner envelope from the outer envelope. You put those aside, remove them, remove. You use your letter opener. This is when you're using your letter opener to remove the inner from the outer. If you see that there are multiple different inner envelopes in the outer and they're not for more than one unit, then those will be disregarded. Once again, put to the side, put to the side. Once you separate the inner envelope from the outer envelope, now you're in a position to open the ballot envelope, which contains the ballot, and you can count up your votes, and whoever gets the most votes wins. That's what's a plurality of the votes. The election is decided by a plurality. So that is whoever gets the most votes wins. If you have a situation where you have a tie, you will have a runoff election. You have to send notice within 7 days, and it must be held within 21, not less than 21 or more than 30. You kind of just run through the same procedure as you did for your regular election with the runoff candidates. Okay, finally, we're to HOAs. I tried to speed it up a little bit to get there for you, because I know we spend so much time on condos, and we don't get to deal with HOAs as much because, frankly, there's not as much in the statute on HOAs. Eligibility for HOA directors, it's very similar to what I described for condos if you weren't paying attention there, because I told you you were permitted to zone out at that time. You can have a requirement in your documents that board members must be lot owners. Sometimes that's not there. It's a frequent misperception that I hear that, it's just the state of the law that you have to be an owner to be on the board. Well, that's just not the case. Sometimes associations are shocked that their documents say that you don't have to be an owner, that somebody's cousin can be on the board, or that a former owner wants to stay on the board. I don't know why they would, but sometimes that has happened. There is no prohibition on co-owners in homeowners associations serving on the board. So, spouses who are both owners can serve on the board at the same time. The felony issue applies to the HOA board members. If you're a felon who hasn't had their rights restored for 5 years before you can step onto the board, you are not eligible. A person who is delinquent in the payment of any monetary obligation for homeowners associations is not eligible for the board. This does include fines, fees, other things besides assessments. If you have pending charges of felony theft or embezzlement of association funds, you're not permitted to be on the board, which is probably good. I have here co-owners are permitted, and no other eligibility requirements are valid. Similar to condos, you cannot amend your bylaws to say, for instance, this is what I see very frequently, you must be a full-time resident to be on the board. Well, that's not valid. We all know these days that many things are conducted remotely. You can be living in another state pretty much the entire year and be able to serve on your board. That is not a valid eligibility requirement. Do not fall into the trap where you're amending your documents to provide for eligibility requirements that are just frankly not valid. I will say for condos, co-ops, and HOAs, you could have eligibility requirements for officers. That's not prohibited by the statute, but I don't see that frequently. It's kind of just a workaround if you feel that strongly about it. HOAs, continuing on, if I can get this clicking to go. Annual members meeting for an HOA is per your documents. When it is, how many days notice. This is not something that is really addressed in detail by the statute. You know, there's no 60-day first notice. Like I said, HOA elections are not the same as condo elections unless you've amended your HOA documents to give you a condo style election. You do have to have an annual meeting though. The HOA Act does require an annual meeting, and that means once a year. That doesn't mean that, you know, we don't feel like doing it this year because everybody's happy with the board and we just had COVID and now we're in a COVID uptick and therefore we just don't think we need to have the meeting. That is not proper. You need to go through the motions even if everyone is happy, and that's great. Maybe it won't be a very difficult process. So once you do look at your documents and figure out when your annual meeting must occur, what the notice looks like, then we can go back to the statute. The statute says that if the bylaws don't provide for a procedure for giving notice of the annual meeting, they are just silent, then a 14-day notice is required. It has to be mailed, hand delivered, or electronically transmitted with the consent of the owner. Some HOA bylaws provide for a 5-day notice or a 7-day notice or a 10-day notice. Those are legit. Those small notices are legit. Your bylaws provide for a time period, and those control. That doesn't mean that you can't give more notice, which is probably recommended, but you frankly don't have to. Let's move on. Okay, well, I've said this about, I think, 3 or 4 times already, but I have a huge warning right here. The election of directors must be in accordance with the procedures set forth in your governing documents for homeowners associations. And frankly, maybe there are not a lot of detailed procedures in your governing documents. Sometimes that happens. It just says the election will, the election will be conducted at the annual meeting, and then you'll have another provision, voting is in person or by proxy, and nominations are from the floor. So you could have a very, very brief procedure, which does raise questions to a number of people who I deal with. And this is something where you're really gonna have to consult with your lawyer and understand what your process is if you do not have a lot of guidance. Sometimes it's a little bit tricky to figure out what you're supposed to be doing as an HOA, which really might behoove you to look at that procedure once you figured it out and say, we don't like this. We want to go to a condo style procedure. We want to have more notice required. We want to do a secret ballot. Those are all things that have to be amendments to your documents. You can't just make up your election procedure. There are many Division of Florida arbitration cases for homeowners associations, because they're the agency that administers HOA election disputes, where HOAs have just kind of like supplemented their document procedures, and the boards have created rules or just informal policies, or they've created policies that are inconsistent with the bylaws. Those are not going to be valid. All the cases say that the bylaws control. You cannot have an unwritten procedure, and you can't just use the condo election style if it's not in your governing documents. very, very important to know. If your property manager is telling you, well, let's just do the condo style election because we know what to do and we think that's easier and it's more equitable. Yeah, that's probably true that it's more equitable, it's easier, it's more known, but that's not your procedure if it's not in your documents. So be careful about that. Effective a while back now, 13, we're no longer required to do nominations from the floor at a homeowners association if your governing documents contain a pre-nomination procedure. If you've amended your documents, or maybe as originally written or amended 20 years ago, they created some pre-nomination procedure similar to the 40-day notice of intent, or just some kind of pre-nomination procedure, you're not required to have nominations from the floor. A nominating committee that doesn't allow for self-nominations is not a pre-nomination procedure that would allow you to preclude nominations from the floor. So just letting you know that if you have a nominating committee, but you don't have any self-nomination procedure in your bylaws, you would still have to have nominations from the floor. At a homeowners association, that is part of the statute. That is part of the HOA Act, Chapter 720, Florida statutes. In a homeowners association, which is completely different from a condo and co-op here, so if you're a condo or co-op, we talked about this, you must have a quorum in order to conduct the election unless there's a pre-nomination procedure in the documents and there were not enough candidates to cause an election. So the default situation here is that most oftentimes for a homeowners association, in order to even open it up, open the meeting to have the nominations from the floor, there must be a quorum of the members present. So what is a quorum in a homeowners association? I think if I asked the question and we had people able to respond here, somebody would tell me, oh, it's a majority. That's what our bylaws say. Well, that's actually incorrect. The Florida HOA Act, the Florida statute here, provides that unless a lower number is provided in your bylaws, lower, then a quorum is going to be 30%. So your quorum could be 25%, 28%, 10%, which is quite low, but your quorum for an HOA association is not going to ever be a majority. If you've been operating under the assumption that you had to have a majority to open up the floor and therefore you can never have an election because you can never have a quorum and everybody just rolls over every year, that is incorrect, and you need to start doing it properly and using the 30% as your quorum. If you truly don't have the quorum there, if you don't have your 30%, that means that there's a holdover board that serves until the next election. If, for instance, if you have 2-year terms, then you do not serve another 2 years. You serve until the next election. That is a common misperception. Your documents can provide for something more specific there, but that's the most typical situation. Election day for a homeowners association. Well, again, this is by your governing documents. It's hard to predict what your governing documents say because they're all just so different on HOA elections. If they're just kind of like the standard documents, you're going to say that the members have the right to vote in person or by proxy. So you'll have a ballot there for people who attend in person, but also this is where we see the proxy wars, where we have a general proxy that somebody, goes around and collects proxies and that they are able to vote on behalf of the person who gave them a proxy in their discretion. So if you want to vote for who you want as a HOA member owner, then you should go to the meeting and vote in person. If you don't mind, then give that person that general proxy and let them vote on your behalf. But you need to understand what they're doing. A lot of times they run around the community and they say, oh, give me your general proxy. And, then they're able to vote how they want for you. So when do we, I have a lot of people who don't like that procedure. They don't like the general proxy procedure. They want to have a secret ballot. They want to be able to vote for who they want. They want to be able to know who the candidates are in advance of that day of the meeting, because it's difficult, particularly right now with COVID, with people traveling, and frankly, because we are not all there, that maybe you want to amend your documents to provide for that double envelope secret ballot method, avoid the general proxy wars. If you do that, if you have amended your documents actually have this procedure, then the people who are not in attendance must vote by secret ballot, the same as the association, that double envelope system. It's interesting that this says the people who are not in attendance. I suppose the people who are in attendance don't have to use the double envelope system, but I wouldn't recommend that. I would recommend that if you have a secret ballot election for an HOA and you're sending out double envelopes to all of your owners because you're required to, that those people who show up the day of, that you also have double envelopes there at the meeting. That is required for a condo and co-op election, although it's not necessarily required here. So at the meeting, depending on whether you have nominations from the floor and a general proxy election or potentially the secret ballot election, everything's opened up, they're tabulated that day, or maybe you have to continue because this process takes so long. But whoever gets the most votes, once again, they're the winners. They are the board. Okay, I told you I would get back to vacancies now, and here we are. Vacancies. How do you fill vacancies? Unless provided otherwise in your bylaws, something very specific, right? That any vacancy on the board can be filled by the vote of the remaining directors, even if there's only one person left. If you have a 5-member board and 4 people resign, then you have that one person appoint the other members to the board. You could take, I guess, some associations like to ask who would like to serve. We have a vacancy, please submit your name and your credentials, and then they give those people a chance and then they select. But you don't necessarily have to do that. You can just select who you want in your discretion as a board. In the alternative, the board may actually hold a special election to fill the vacancy, unless otherwise provided in your bylaws. Now, if you have a multi-year term, then your appointed board member is going to serve out the balance of the term. Filling vacancies created by a recall is completely different. That's under recall law, and it's very detailed. We won't get into that right now, but I want to make it known that filling vacancies from somebody who's, resigned, moved, is completely different than filling vacancies under a recall. Moving on, remote meeting best practices. Okay, so here we are today with another COVID surge. Who thought that this would be going on so long? It's extremely, extremely unfortunate, but we are fortunate that we have been able to have what we sit here today on Zoom, other platforms, and we are able to continue conducting business. But emergency powers of associations are no longer there. We don't have the power to have a Zoom only meeting. People ask me all the time, oh, we can't do it, we don't have the space. Well, you have to offer some type of physical location for your meeting, and you can have Zoom in addition to the physical location. You can request that people kindly attend by Zoom, and we're trying to limit the amount of in-person attendance. While in-person is available, we strongly recommend that you use a remote method, and maybe the owners will oblige, because it is difficult out there these days. Best practices, if you're going to do this, because maybe there's no appropriate physical location because of CDD guidelines, other guidelines, you have a demographic who is very vulnerable in your community, again, option in addition to physical attendance. I would encourage you to keep noticing your meetings in a hybrid fashion. That's what we call it. That's what all these condo lawyers call a hybrid meeting. That would be in person and via Zoom. Remote meeting procedures, they actually are authorized for membership meetings, but they're not required. You can't require somebody to have a Zoom meeting or require that somebody attend via Zoom. If you would like to keep your remote meetings ongoing for membership meetings, annual meetings. There is a procedure to follow. And really the procedure is that the board holds a meeting and the board authorizes the remote meeting and sets forth parameters for attending and voting. It's not that complicated, but I would recommend that if you're going to continue doing these hybrid meetings and you have not authorized the remote participation, that you have a board meeting and quickly adopt some terms under which the members can attend and be present and vote. If you're going to have the hybrid meetings, maybe you limit the agenda, ask members to ask questions in advance if possible, because that'll cut down on a lot of the tech issues. I've had a lot of associations with success really, asking for cooperation, and the owners have really been very helpful. If you say, listen, everyone is allowed and authorized to speak at meetings. We realize that, but we would strongly encourage you to ask your questions in advance such that we can be prepared, frankly, and that there's not a lot of this back and forth and having a tech problem, because I can understand that. I'm not very techy, and I've seen some difficult meetings because of tech back and forth. If you're a condo or HOA association that uses secret ballots, you must still have the secret ballots, or particularly for condos, at the meeting, at the physical location. Somebody might walk up that day and say, I haven't voted yet, I need to vote, and I need to get my ballot and I need to get my envelope. Again, proxy forms as well, particularly for HOAs. For condominium associations, the Zoom is helpful, obviously, but we need to be able to comply with law, which means opening ballots in the presence of the owners. So if you're going to be doing the hybrid meeting, I would recommend that you have your camera set up in a way that the members who attend remotely can still watch the process. I would highly recommend that. Electronic voting. We talked about that before, and this is not electronic notice. This is electronic voting through a web-based platform. You can do this if you authorize it. It's not an automatic right for your association. If you're going to authorize electronic voting, I would recommend that you get with a provider to discuss what their procedures are, so you understand what their program is, so you know what you're getting yourself into. But you have to authorize it at a board meeting. This is not a membership vote, it's a board vote, but you have to provide a 14-day notice of the board's meeting to consider adopting electronic voting. And then at the meeting, the board has to adopt a resolution to provide for what the procedure is to, to use the electronic voting system. So for instance, you have to set forth how many days in advance you have to opt into the procedure. You have to confirm at least 14 days before the deadline that the owner's device can communicate with the system. So your provider will send out like a test email. So there's some parameters that you have to deal with here, and they're all set forth within the resolution that authorizes the implementation of this voting, which is what we here at K. Bender Rembaum do. We do this very frequently for our clients. We prepare a resolution with all of the pertinent dates that you have to comply with, and that's pretty standard procedure. I also mentioned if you're a condo association, the first notice must disclose the procedure and deadline to consent to electronic voting. If you fail to include that, your opt-in form, basically, your opt-in to, you want to do it, then your election can be invalidated, actually. I guess the point of that is if you've authorized electronic voting, you have to tell the owners how they can deal with it, how they can opt in, how they can opt out. And that's only fair, right? We want them to use the program. The programs are great because it eliminates you having to open and physically count so many ballots, especially for those of you that are dealing with associations that are great in number. even up 200, 300, 400, when you're up to that thousands, of course, that the electronic voting has been so helpful because it's cut down on the amount of ballots that physically have to be opened and then tabulated, hash marked or however you're tabulating your votes. It gets very complicated, and sometimes if there's a close election, then you'll have to recount so many times. Of course, not everyone is going to consent to the electronic voting, so sometimes you'll have a combination where you'll have some people voting electronically and some people voting traditionally, and then you'll add up all of the votes and you'll have a total. That's how that works. Election of officers will occur after the annual meeting. This is usually at what's known as the organizational meeting. Sometimes that's held right after the election, but keep in mind, this is a board meeting that must be noticed with a 48-hour meeting notice. So you have your second notice of annual meeting that you sent out for a condo, or however you must do it for an HOA according to your documents. Make sure you include another, squib that your organizational meeting will be held following the election, but then also you have to post it. It's a board meeting. All board meetings are posted no less than 48 hours in advance, so you also have to post that notice. This is the one time that association directors can vote by secret ballot. This is not a secret meeting, this is an open meeting, but it can be a secret vote. So you can rip off a little piece of paper and I want to vote for Sue, I want to vote for Sally, so there's no, nobody feels bad, I guess you could say. It doesn't have to be a secret vote, but this is the one time where a director can vote in secret, not a secret meeting. Not a secret meeting, an in-person open meeting, an open meeting. Once you elect your officers, there's no prohibition against changing officers midstream during your year. Sometimes somebody's just not working out as president, and you all get together as the board otherwise, and you agree that you will hold a meeting and reorganize your officer positions and vote to frankly remove them as president and appoint somebody else, elect somebody else as president. Maybe it's the treasurer who's working out, but oftentimes I see this issue being that the president is being replaced. Board certification requirements. 90 days after being appointed or elected to the board, you must either take an educational course, which we give very frequently, or you have to certify in writing that you will agree to read the documents, uphold all the policies of the association, and faithfully discharge your fiduciary duty to the association members. I strongly recommend that you take a course. You will learn a lot. You do not need to take a course every year if you continue to serve on your board without interruption. Also, you can take this course within 1 year before being appointed to the board. So there's many options here. Strongly recommend you attend a course. There's just so many details in the law regarding condos, co-ops, and HOAs that even if you've taken the course, when you first got on, take it, every year with your other board members or every other year. There is a pending bill, I believe, in the legislature right now. Again, it's not law, it's not current law, it might not be law, that eliminates the option where you can sign a form and requires everybody to take this course. We'll see what happens with that. Very quickly, because we are running out of time, and I know I'm speaking very quickly at this point, just a couple things regarding election challenges. If you are not happy with the election, you don't think the process occurred properly, you think something was wrong, you think that you should have been elected and you weren't, you have 60 days after the election results are announced to challenge the election. You might need to have some official records to challenge the election. So official records for condos and now HOA, ballots, sign-in sheets, proxies, other envelopes. These are only required to be kept 1 year now. Notices must be kept for 7 years in condominiums, HOAs, and co-ops. And minutes in the condo, as of, I believe, a couple of years ago, have to be kept in perpetuity, meeting minutes. So new HOAs, this is good for you. You don't have to keep all of your ballots and envelopes, if you have envelopes, proxies, for 7 years anymore. It is a 1 year process. 1 year limit. So I talked about challenging the election. Challenging the election, you must do it within 60 days, but the law has changed now. So and you have different options. In order to challenge an election, you can go to the Division of Florida Condominiums. That has always been where we hear election disputes for all three associations. You can keep going there, and there's a body of law at the division dealing with election disputes, or actually you can file a lawsuit in circuit court as of July 1. If you're an owner and you had maybe you've already been to the division before and it was maybe slow, or you didn't like the result there is an option now to go directly to court. I will say these are time-consuming processes, so I have not seen anybody file in court yet, and that is yet to be determined to see how a court reacts to an election dispute. I think it should be pretty interesting once we do start seeing these disputes brought in court. Then we might see these court cases appealed to an appellate court, and then maybe we'll have some appellate law on condo, HOA, co-op elections, which we have very little right now. We have very little appellate law, which is binding, right, on association elections because they've been required to be brought at arbitration. So now we will see how that all plays out. Recall, if you are not happy with your board and 60 days has elapsed from the election, you can start a recall. A majority of the entire membership of the association have to vote to recall a board member. It's not a majority of a quorum, it's not 30%, it's a majority of all of the membership. That's pretty clearly established in the law. You cannot do a recall when there are 60 days or fewer until your election, because you're about to have an election anyway. So the law says that that's not going to be heard by an arbitrator or a court, because it doesn't really make sense. Your case won't be able to be heard that quickly. The election is upcoming, and therefore no recall will be heard. Wow, I feel that I got through a lot of material today in a very short amount of time. I hope you enjoyed the course and that you learned some. I know that these election issues tend to be pretty specific as to your community and what's going on there, whether you're a condo, whether you're a co-op, whether you're a homeowners association. I encourage you to read your documents regarding your election procedure and your meeting procedure. I encourage you to also contact counsel if you have any questions regarding this, because it is important. You don't want to have your elections susceptible to challenge. We want to avoid that, and we want to do it right the first time. I very much enjoy presenting to you today. I hope everyone has a wonderful day and everyone stays well.